Chair, and thank you for appearing before us today. I'd like to start with you, Dr. Wallace. We heard testimony earlier. The asylum claim backlog, as we knew, was already in the hundreds of thousands due to failed liberal immigration policies, quite frankly, over the last 10 years. They've now put forward this bill that will make the process less efficient, less fair, and it certainly will increase costs. Would you agree that it at least appears that through this legislation, Liberals are trying to offload responsibility for the mess that has been created?
I would say that I have a real concern that the overall efficiency of the system is going to decrease when things are moved around, that essentially more bureaucracy is going to be created as opposed to streamlining bureaucracy.
Well, let me ask you this. Do you think it could be challenged in the courts?
I'm a law professor, so my job is to say a lot of things can be challenged in the courts. My expectation is that there will be constitutional challenges.
And sorry, can you repeat that?
I expect that there will be constitutional challenges, that somewhere along the way a client will instruct their lawyer.
There's these huge powers in here, mass cancellations and all kinds of stuff. So my challenge, if it's not going to pass a court challenge, literally what the government is doing is leaving its policies to be made by the Supreme Court potentially, which is, we've seen that happen as recently as this week.
Yeah, it could happen.
Yeah, absolutely. I'd like to ask you a question, Ms. Okunachov. Sorry, did I pronounce that right? I'm sorry if I didn't. With a name like Menegakis, I got a lot of mispronunciations. I just want to reiterate your testimony a little bit. Would you recommend amending the mass cancellation provisions on Bill C-12 to include parliamentary oversight requirements? For example, something like a requirement to post the intent to use the provisions with sufficient details, and say a requirement for committee study?
Yes, absolutely. I also just question why this would be something accomplished through order in council. I think the regulatory process, which at times even includes a regulatory impact analysis statement, and the typical process, I think, does help inform committee study.
Thank you. That's very informative and very helpful. Back to you, Dr. Wallace. Do you believe the IRB offers a more comprehensive and accurate review of claims, and you call them PRAs, so I'll use the acronym PRAs?
I do.
You do. Okay. So what procedural safeguards do you see are being stripped away that are available in the full IRB hearing compared to PRAs?
I mean, a long list. The big one, of course, is the right to an oral hearing, which is something that you presumptively get at the RPD. The IRB also just has a robust infrastructure to support decision-making. You heard this morning about training. You heard about the research directorate, about legal services, about mentorship. The IRB's sole job is to make well-reasoned decisions. IRCC has many, many, many jobs. And the just simple reality is that my view is if you give someone a specialized job function, they can specialize well in it.
Given that you're a lawyer and
a recovering lawyer.
Let me ask you this. Would you agree that shifting the responsibility for complex decisions of the IRB to a system with obviously fewer procedural safeguards, as you have just agreed to, have said, will inevitably result in an increase in applications for judicial review at the federal court?
Yeah, I do.
So potentially we could be clogging up our courts with I mean, there's hundreds of thousands of these applications out there. The legislation will inevitably lead to an increased burden on the federal courts of Canada, of course, but have you estimated the increased costs associated with this in any way?
I wanted to. It's very difficult because there's so many variables I can't control for, and I didn't want to predict. One thing which I will gesture at is I would expect this will show up in legal aid budgets, where if we're also seeing more JRs, those are just inevitably more expensive, and I would expect some materialization there.
So given the fact that the federal court system is already inundated, it can take months or even years. Does this not lead to a net increase in the total time an asylum claim can take?
It could, and I would say that when you have a backlog at the federal court, it has downstream consequences throughout the entire judicial system, impacting other areas of law, not just immigration law.
So in the last 30 seconds I have, a question for all four of you. Do all four of you think that this can be challenged in court? Or will be?
Yes.
Yes?
Yes, absolutely.
Is it unanimous yes?
There's numerous provisions, there's vague language, it's overbroad, there's constitutional concerns around Section 15. There's a lot of reasons it would be challenged.
Thank you very much. Thank you. Thank you.
Thank you, Mr. Menegakis. Thank you. Now we move to 5-minute rounds, and I believe we have Mr. Ma, who will begin for 5 minutes. Thank you.
Thank you, Madam Chair. My questions will be addressed to Ms. Okun-Nachov. Earlier today, you talked about the report you published this year, I believe is titled Law, Technology, and Accountability. In Section 2.1, you speak out against top-down and ad hoc nature of ministerial instructions, public policies, and technocratic decision-making. You also outlined that these non-regulatory instruments weakens the public confidence in the system's integrity. So do you feel that Part 7 of Bill C-12 is further breaking the Canadian immigration system by taking us in this direction of top-down, ad hoc, and technocratic decision-making?
In a word, yes.
Thank you.
I think that the Canadian Bar Association spoke quite clearly about the fact that the creation of ministerial instructions was a way of subverting the regulatory process, and we have seen how it's created a real patchwork of different programs that have made it difficult for people to follow what the avenues were and have diminished transparency for people who are coming to Canada.
Thank you. In the CBA National, there was an article of advertising your 100 recommendations, again, you mentioned earlier. And you said that there's a joke around immigration section that if you go out for a cup of coffee, when you come back, then there are new rules in place. You spoke of the lack of transparency, consistency, discussions, and debate on working through policies before they're enacted and started.
Point of order. Sorry, point of order, Mr. Ma. Sorry about that. Yes.
Madam Chair, the bells are ringing.
Oh, thank you. The bells are ringing. So I would need unanimous consent to continue at this point in time. Can I get unanimous consent for us to continue to 5:30?
No.
Okay. Since we do not have unanimous consent, I will now adjourn the meeting. And before I do that, thank you so much to our witnesses. That was excellent. Thank you.